the day. I hope you're all like awake and energized and ready for some more thought-provoking discussions. The title of our panel is Reconsidering the Role of Employers in Healthcare Delivery. So I'll begin with a short introduction of our panelists, but I certainly encourage you to read their full bios on the conference materials. Our terrific panelists include David Koeninger, Seema Mohapatra, is that it right? Margaux Hall. David is the managing attorney for special projects and program performance at Advocates for Basic Legal Equality in Ohio. He specializes in government benefits, health care, and federal taxation. He has served as the principal drafter of amicus brief in support of the proposed Medicaid expansion filed on behalf of Ohio's legal services providers. A former clerk to the Honorable Avern Cohn, U.S. District Court for the Eastern District of Michigan, David received his JD from Michigan Law and his BA from Dartmouth College. Seema Mohapatra is an associate professor at Barry University School of Law and teaches medical law and bioethics for Kaplan University. Seema practiced healthcare law at Sidley Austin, has been involved in health law-related legislative advocacy, and taught as an adjunct at Loyola University Chicago School of Law. She received her JD from Northwestern University and a master's in health from Yale. No stranger to Baltimore, Seema earned her bachelor's degree at Johns Hopkins. Margaux Hall is the Center for Reproductive Rights Academic Fellow at Columbia Law School. After graduating from law school, Margaux conducted health and human rights research in South Africa as a Fulbright Fellow and in East Africa as a Harvard University Frederick Sheldon Fellow. She then worked in private practice at Wilmer Hale, and most recently, Margaux spent more than 2 years working with the Justice Reform Group of the World Bank's Legal Vice Presidency in Sierra Leone. Margaux received her JD from Harvard Law School and a BS from Stanford University. Our panel addresses issues that we can all relate to and begins with David's historical look at how we got to the place where employers make healthcare decisions for employees. David identifies similar themes of dependence and disparity in the healthcare discourse at the time of Reconstruction, leading up to our current healthcare debates. Seema continues the conversation with her analysis of reproductive health law cases stemming from the Affordable Care Act through a corporate law lens. She will explain why a shareholder's constitutional religious exercise rights do not extend to the corporation itself. And lastly, Margaux will round out the discussion when she examines the structural problems with having employers negotiate the healthcare benefits of employees. She proposes that employers are legal fiduciaries investing money on behalf of employees who functionally pay for their health care via a wage-benefit trade-off. Each panelist will speak for 15 minutes, and then we'll have time for question and answer. Thank you. Let's start with David, please.
Okay. I want to make sure I'm okay. Folks can hear me? All right. I want to thank the conference organizers for having me here. This has really been great. I really enjoyed this, and I've really felt, especially with the panel this morning, that yes, there are other people out there who are thinking about this the way that I am. So, so that's really been great for me. I want to try to make 2 points today. My first is that the Affordable Care Act is a civil rights law. Think of it, if you will, as anti-subordination legislation. And the second point I want to make is that in order for the act to be effective, to reform our healthcare system and to achieve those anti-subordination goals, we have to refocus the debate or change the narrative or reframe, as folks have been using the expression, so that the discussion about the Affordable Care Act becomes about those who will benefit from the policy changes that it includes, those that are designed to reduce health disparities and to remedy the effects of race and gender discrimination. So I want to start by talking about the term path dependence. Professor Huberfeld, Nicole Huberfeld, uses the term to talk about the Medicaid program and how it denotes the idea that history can dictate a set of rules that relates to a specific choice, which makes the choice less deliberate and less voluntary than it might have been because you made that initial set of decisions that govern the subsequent behavior. And in both our government healthcare systems and in our public-private healthcare system, path dependence has been critical. Past decisions have influenced future decisions. And so given that significant role for history, I want to talk a little bit about history. So I'm going to try to go fast through about 150 years of stuff. And I want to do that because I want to highlight the way in which our healthcare system has evolved with the emphasis on work versus dependence, the worthy versus the unworthy, the deserving versus the undeserving, and the incorporation of discriminatory societal norms that dates back to Reconstruction. And we have to highlight this history in order to be able to respond to the challenges to the ACA today, which is trying to undo some of these emphases and to dissolve those discriminatory norms that have been part of healthcare for so long. So, back to 1863, the Emancipation Proclamation is issued. 4 million formerly enslaved persons are now free to seek work, but if they can't find it, well, then they're subject to hunger, lack of housing, and ultimately sickness and disease. So we have this kind of internal refugee problem that Congress finally decides in 1865 that it needs to address, and it creates the Freedmen's Bureau, which includes the first ever federal health care program. And the process of setting this up is described in a book by Jim Downs called Sick from Freedom. And as he explains, the federal government's intervention in health matters in the South included two critical emphases. First, the federal government's obsession with freed people's labor circumscribed how freed people's health would be defined and who would define it. That is, the federal government's primary interest in the health of freed slaves was linked to its desire to take advantage of their labor power. So here you have the first instance of employers defining health for the purpose of taking advantage of an individual's labor power. And in fact, the federal government separated those who weren't able-bodied from those who could work. Second point of emphasis, because of the federal government's obsession with freed people's labor, they were very concerned, very anxious about providing government health care to able-bodied individuals that would render them dependent on the federal government. And so they were so concerned with that they did a bunch of things that ultimately undermined the success of the Freedmen's Bureau Health Program. So we have these kind of three themes that carry forward. We have health is defined as the ability to provide labor, and that someone else defines health for you. We have this emphasis on tailoring benefit programs to aid those who aren't able-bodied or, as with children, are not able to work. And three, we have this corrosive anxiety about creating government dependence by providing assistance to the able-bodied. So, fast forwarding, we go past World War II. Truman tries to implement national health care, is unsuccessful. So instead, we look to employee health care in context of private employment. And until the late 40s, it wasn't the subject of collective bargaining. But both employers and unions had attempted to use medical care as a means of sort of developing worker loyalty. Employers, of course, also wanted to kind of be able to send you to the company doctor and have the doctor say, oh yeah, you're good enough to work, and unions sort of in response said, I don't know if you can return to work. And so you had that thing going on, and but what ultimately happens is that it becomes part of collective bargaining after Inland Steel, and the unions decide that, well, this isn't what we'd like. Ideally, we'd like a program of national health insurance, but we're not going to get that. So we'll take what we can get in collective bargaining, and it is a benefit to our employees. So, our system of employer-based health care gets set up, and, it's never really served the interests of whole groups of people, which is why we've needed health care reform. If you're unemployed, if you're self-employed, if you work at a low-paying job with no fringe benefits, this didn't help you, obviously. Employers, on the other hand, probably benefited the most from this arrangement because they avoided having mandated national health insurance, but they kept control over, choice of insurance carrier, plan details, things like that. So they retained that ability to define health for the employees, right? So, skipping forward a little more into the public sector now, that is government-funded health care, into the 60s. And we have the Civil Rights Act of 64 and Medicare and Medicaid. And so what we get out of Medicare and Medicaid being enacted is this sort of striking example of path dependence. Because you have two War on Poverty era programs that track the lines that were drawn by the Freedmen's Bureau for administration of its aid during Reconstruction. The aid that will be provided by the government through Medicaid and Medicare will assist only those who, by necessity or by definition, are dependent on the government and therefore are not otherwise considered to be able-bodied. Now, having Medicare and Medicaid, has assisted millions of people. It was a good thing, in general, but it didn't go uncritiqued by the left. And so I found it interesting that the Black Panther Party was particularly critical of Medicare and Medicaid because, for exactly what the reasons I'm talking about, the Medicare and Medicaid programs incorporated the limits on governmental involvement in health care that arose during Reconstruction. And the way the Panthers saw it in order to get access to health care, you had to demonstrate that you were sort of possessed a damaged biology. So you were maintaining or proliferating this racist myth that blacks are somehow biologically inferior. They're inferior because they didn't want, or they couldn't get, or they couldn't keep jobs, so they couldn't get health care through employment, or they wouldn't qualify for Medicare. But if they're willing to present themselves to the government as somehow damaged or dependent, welfare moms and children, or sick and disabled adults, well, then they could get Medicaid, right? And so, like the freed people in the Reconstruction era, what the Panthers were saying is what we want is citizenship and the rights that come along with that, and to be treated equally and to not have disparate access to health care. But instead of that kind of citizenship, what they got was sort of another dose of stigma. So along comes, jumping forward now to recent era, along comes the Affordable Care Act. And it challenges some of these things that have been set up and attempts to challenge path dependence, and that's why I think that it meets this resistance. And so first I want to talk about the Medicaid expansion. Now, as it was originally written, the Medicaid expansion would have made Medicaid much more like Medicare. There would have been a national standard, across all states whereby people could become eligible. Of course, the Supreme Court made that optional. And in doing so, the court found that, the spending power couldn't be used to create this new program. Well, in order to find that it was a new program, Justice Roberts has to go back to the Freedmen's Bureau model, right? So he has to hold that a program to help the indigent and disabled is one thing, but a program in which able-bodied persons with low incomes can access health care is, quote, a shift in kind, not merely degree. So it was, by shifting to a program that would cover both the deserving and the undeserving poor, that, you somehow violated the spending power, because this was a new program. One other thing I want to mention about the Medicaid expansion that I found really interesting is that in the states that have adopted it, there's a different income methodology. It's called modified adjusted gross income. And what that does is it has the effect of eliminating one of the old stories of the welfare queen mythology that we've had in our past, the spouse in the house story, right? Because it used to be that, in the South especially, but in other places too, there'd be midnight raids on welfare recipients to see who was in the house at night. Because if you were, a dependent woman with children and, and no spouse, no other source of income, there shouldn't be a man living there. Well, what the Magi income eligibility standard does is it gets rid of that, because it says we look at what income you put on your income tax form. So unrelated adults living in the same household don't need to be counted. So here in this, this one small point is it really is an interesting part of how the ACA kind of ends that, that path dependence and the focus on deserving versus undeserving. So you see in the spouse in the house storyline this nexus between women's sexual autonomy, access to health care, and the notion of deserving and the undeserving poor. So another thing that the Affordable Care Act does, and I'm just going to touch on this briefly, is it loosens that connection between employment and access to health care, right? And so we had this CBO report recently about how the ACA would reduce the total number of hours worked by 1.5% to 2% from 2017 to 2024 because workers will choose to supply less labor. How's that for free labor? I mean, the ability to obtain access to health care by means unrelated to their employment is going to cause workers to choose to work less. Think about that. So we're getting away from, or that's one way in which we can get away from this notion of employers deciding what health is, right? So that brings us up to, the Hobby Lobby cases and the related cases regarding the contraception mandate. And there are now, we were told yesterday, some 100 challenges pending. And in this next wave of cases, there's really sort of two kinds of cases. The Hobby Lobby cases, where you have a corporation that is attempting to argue for that it is exercising its religious values. And then there's a separate set of cases that involve the certification that I want to get the terminology right, the qualifying organizations that have a religious reason for wanting to deny birth control that have to certify that that they don't think they can provide, they don't want to provide birth control, and then you get the birth control from the insurer instead, so that they're not involved. Those are kind of a separate set of cases, which I don't think I have time to talk about, but there's some interesting aspects about those that make them different from Hobby Lobby. What I wanted to talk about regarding Hobby Lobby, we had a great explanation this morning about how RFRA plays out, and the free exercise clause and what all that means. I want to say that these cases, even though they've been framed that way, hence the need for a new frame, are less about religion than they are about control. The Hans complain of being required to purchase religiously objectionable products for others' use. However, but granting them a conscientious exemption to the contraception mandate imposes their conscience on the company's 950 employees. In their briefs, Hobby Lobby and Conestoga try to diminish this argument by emphasizing that their religious beliefs are well known and permeate their business practices, and sort of implying that employees who don't share those beliefs just aren't likely to want to be employed by their companies. And as was said this morning, if that were really true, there wouldn't be any need to oppose the contraception mandate. No one would be buying contraceptives or using contraceptives. And of course, economic reality dictates that that's just not true. And as Professor Corbin noted this morning, that's the problem with the notion of corporate religious freedom. There's this disparity in power, so the owners get religious liberty, but the employees don't. And what you really see here is the Hans and the Greens seeking to reach into some of the most intimate details of their employees' lives and dictate certain behaviors, kind of like the states in the spouse in the house cases. They want to have some control over women's sexual autonomy. And I think this is merely another method of drawing a distinction between the deserving and undeserving poor. And the undeserving poor have a very old history. They represent the enduring attempt to classify poor people by merit, and as we know, thanks to Mike Huckabee, characterization of lower class or working class individuals as morally suspect and particularly sexually promiscuous has been an American tradition. Sort of implicit in the notion of what the Hobby Lobby employers want to do is that good employees will seek to emulate their employers and be like their bosses. And why should we want to pay for something that is not part of what would keep an employee healthy enough to work? Why should we be concerned about their health in any context other than just making sure they can show up and do a day's work for us? So, to reiterate what's been said, path dependence comes from history. We need to acknowledge that history. We need to find a new. We need to find a new narrative. We need to start talking about, take conscious steps away from it. Start talking about anti-subordination. The idea that we can only end race and gender-based practices furthering subordination of those who have suffered a history of discrimination if we acknowledge those practices and take affirmative steps to go forward. The ACA challenges path dependence and tries to loosen the links between employment and access to health care, and so is an anti-subordination project. If you will, the ACA supports free labor and women's sexual autonomy. And this is going to require us to do some significant work, however, because the Obama administration kind of doesn't seem to understand this as they've been defending the ACA. So if you look at the amicus brief, and again, folks alluded to this morning, of the National Women's Law Center in Conestoga Wood Specialties, it says this very directly. Employers that exclude women's preventive health services from their health insurance plans while covering men's preventive health services discriminate against women. Clear enough. There is nothing so straightforward and direct in the Solicitor General's briefs. Indeed, in their response in the Conestoga Wood Specialties case, the government takes pains to express repeatedly that the Hans beliefs are sincere. I would submit that taking such a defensive posture is no way to convince the court of the compelling nature of the government's interests. In fact, Conestoga Woods actually gets to the point of arguing that requiring a corporation to provide access to birth control in its employee health plans amounts to government interference in the lives of citizens. Requiring access to birth control infringes on the lives of individuals. It argues that a woman's attempt to secure access to preventive care through her employee health plan is an infringement on the rights of her corporate bosses. And so there you see, writ large, this idea that we get to say what health is and what services you get in order to preserve health. You don't get to say what your health is or what services you get to take in order to preserve your health. So what advocates for the ACA need to do is to make the ACA implementation cases about the rights of those who will benefit from the ACA as it addresses the unfinished business of civil rights. Rather than trying to defend the ACA from death by 1,000 cuts, somebody said this morning there are more cases to come, and there will be. We need to, to find ways to affirmatively support and promote the ACA. Perhaps to find ways to bring affirmative litigation. There is that EEOC decision out there that says that denying women access to contraception when you provide men other preventive care is a violation of the Pregnancy Discrimination Act. We can pursue Title VII actions. There's some suggestion. There's a wonderful brief that was written by Marcy Hamilton saying that the court should, on its own motion, just find RFRA unconstitutional. And so maybe there's some ways to get after that issue as well. And I think this is really important, not only to win the cases, but to win the debate, right? There's actually, I've been concerned about this for a while, and it turns out that Keith Erickson and Judd Kessler actually did a study of the individual mandate and how the debate over the first Supreme Court case affected people's perception of the individual mandate as whether it was a mandate or a tax. And they found that after that year of debate had gone by, people were less likely to buy health insurance because they considered it to be a tax than they would have been otherwise. And so you have this sort of policy consequence of losing the debate that, healthier folks are not going to buy the insurance, and therefore insurance is going to cost more for everybody. So we should take these findings seriously, and again, we need to find that frame and to find ways to affirmatively support the ACA and those, HER, the folks with existing rights granted by the government. Thanks.
Thanks so much for having me here today. I've really enjoyed the talks and yesterday's keynote and the workshop, and I love the theme, applied feminism and health, especially as a feminist professor who teaches both business law and healthcare law. This paper and presentation is a great opportunity to use all my hats at the same time. The title of my paper is Time to Lift the Veil of Inequality in Healthcare Coverage, using corporate law to defend the Affordable Care Act's preventive health services mandate. It's a mouthful. Today, the paper is quite large, and I'm not going to talk about everything that I'm going to cover in the paper. So rather, in the paper, I start with talking about the ACA and gender equality, some of what David had just talked about, and then I talk about the cases, the Hobby Lobby and Conestoga Wood cases, and the HHS preventive health services rule, and I'm not going to do that today because I think that's been covered a lot, and this is an audience that knows that the ACA does a lot for gender equality. So I'm going to actually look at just the corporate law aspects of my paper, and one of the things that I do is I'm basically responding to an argument that's out there in the literature now that somehow the way that Hobby Lobby and Conestoga Wood and other plaintiffs are asking that as shareholders or owners of a for-profit corporation, that their religious beliefs somehow should pass through from them, the shareholders, to the corporate form, and using some corporate law principles. What's in the literature right now, there's one professor, Stephen Bainbridge, that has written quite extensively on this, that somehow this is a notion that is founded in corporate law. I disagree completely, and I go through a doctrinal analysis of that. So that's what I'm going to do today. And so I'm going to skip all these other things that I do in the paper, and I'm going to go straight to the corporate law analysis. So the first thing that I do with the corporate law analysis is I go through several different corporate personhood theories and talk about how those theories comport with the idea of whether a corporation can take on the religious beliefs of its owners. And then I go through this concept of piercing the corporate veil, and if that works with this, with the plaintiff's arguments, and in both cases, I argue that they do not work. So I'm not going to go through this in that much detail, but the three theories that I go through with the corporate personhood are the concession theory, which is basically sees the corporation as a creation of the state or sovereign that grants its charter, and so the state can control or limit what it can do. Now, the concession or artificial entity theory has fallen out of favor in American law, and so I really focus on the real entity theory and the aggregate theory. Now, the real entity view of corporations sees corporations as having a separate identity, an identity that is more than the sum of its parts. And it's difficult, if you ascribe to this view of corporate personhood, that the corporation is a person, a real person, and some of the Supreme Court jurisprudence in the past has shown that the Supreme Court has ascribed to this theory in the past, it's hard to argue that the shareholders' religious beliefs then can be taken on by the corporation. And there's some amicus briefs that argue about this, about the real entity theory, the amicus briefs by the corporate law professors. The response to that has been, well, the way legal scholarship has gone, the aggregate theory or the nexus of contracts theory of corporate personhood is much more in vogue, and that does not look at a corporation as a separate entity, but rather as a set of relationships, a nexus of contracts between the different parties involved in a corporation. So shareholders, employees, creditors. And so if you are going to argue that, well, no, there is no real entity theory, corporations are not their own person, there's a nexus of contracts, I argue, and that's usually the more law and economics theory, and that's a theory that actually I think adds a stronger case for arguing against the idea that the corporation itself has some kind of beliefs, because we have all these parties involved, and not just the employer's beliefs or the owner's beliefs, but we have all these parties. And in my paper, I argue that if you let only the employer or the owner dictate what beliefs the corporation is going to own, is going to, that's going to be recognized by the courts, you are going to have problems, because freedom to contract often means exclusion of women, of minorities, racial and otherwise. And I argue that this view does not make sense. Owners are just one of the many inputs in a nexus of contracts theory. So the next part of my paper kind of goes to the veil-piercing arguments that have come about in the literature, and I'm going to do a little mini corporate law session, which I know that's exactly what you guys want to do after lunch today. But I will, just so that I can review what I'm talking about. In an ordinary, limited liability is a defining factor of a corporation, and so ordinarily, when you incorporate, the corporation has its own. The shareholders as owners of the corporation are not going to have any personal liability, which makes corporations a better form than a partnership. Now, veil piercing refers to the rare circumstances when a court decides to disregard the corporate form and disregard limited liability and go straight to the assets of the individual shareholders. And this usually happens in cases where there's a tort creditor and the shareholder hasn't been keeping corporate formalities, and there's some reason to think that there have been commingling personal assets, and there's some reason to actually pierce or disregard the corporate form, which we do not have, obviously, in these kinds of Hobby Lobby cases. In the Hobby Lobby cases and Conestoga Wood cases, we're talking more about a situation where an insider, the shareholder, is trying to ask the outsider to say, no, I want to, the claimant is attempting to say, well, I want to have the shareholder be regarded as the corporation themselves. And so I argue that this is a very veil piercing is rare. Reverse veil piercing is even more rare. And then there are two types of reverse veil piercing. And one is when we have an outside party coming in and trying to say, well, I want the corporation's assets as the shareholders' assets. And often this happens with like the IRS. So the IRS is trying to get the funds, trying to attach to the funds of a shareholder. The shareholder is bankrupt. They say, well, no, we're going to go after the corporation's assets because you're an alter ego of the corporation, and you're trying to skirt legal obligations by that. Okay, so that's not the kind of case that we're talking about here in Hobby Lobby. We're talking about the cases where we have insider piercing claims. And so in the insider piercing claims, that's even more rare than the other types of reverse veil piercing. And so I have an example here. Some of you guys might have covered this in business law. I usually skip it because it's confusing to the students. So I will try to make it as simple as possible. This is from the Cargill versus Hedge case. And what happened in this case was there was a husband and wife that transferred their interest in their farm to a family farm corporation, and the wife became the sole shareholder. There was a judgment against the husband and the corporation, and a creditor successfully bid on the property at an execution sale. So state law in this case provided for a homestead exemption, meaning that even if you're bankrupt or you have a judgment against you, you're not going to have the home that you live in taken away from you. And so it exempted from seizure the house owned and occupied by the debtor, and the lower court found that this exemption did not apply to a corporation. And what happened in this case is they avoided this prohibition by permitting the owners of the corporation to reverse pierce the corporate veil. So this is an example of the similar situation as we have here. But in that case, there was a strong public policy concern that the court referred to that overshadowed its concerns that, this conclusion basically ignores the corporate entity. But this is a totally different case from when a corporation is actually trying to take away a right that its employees would have. That was not the same kind of public policy reason where this kind of framework would work. And many courts are continually hostile to this insider reverse veil piercing theory because there's a hypocritical nature of it, right? You have a corporate entity that's trying to get limited liability and different benefits of the corporate form, but when it's convenient, they're saying, no, really, I'm the same thing as the corporation. And that's what I see happening here. And in the Conestoga Wood case, in the lower court, there's actually a quote that talks about this and says it would be entirely inconsistent to allow the individual plaintiffs to enjoy the benefits of incorporation while simultaneously piercing the corporate veil for the limited purpose to challenge these regulations. Now, so I argue in my paper against using this as a framework completely, but then I go on to say even if you use it as a framework, it fails. Because the test that you would use, so the first prong of the test is there such substantial identity of the shareholder's religious beliefs in the manner in which the corporation is operated and purposes for which it's devoted that the corporation is effectively the shareholder's alter ego. Even being generous, arguing in Hobby Lobby, maybe, okay, they're closed on Sundays, they have all these, mission trips and different things they do, maybe there is substantial identity. I don't even go that deeply in the paper with that, I don't agree, but the other two prongs, I think, how strong is the government's interest in ensuring that the corporation's employees get the mandated insurance coverage? Very strong, and I go through the public health aspects of it. And then would reverse veil-piercing advance significant public policies? No, I argue that it would do the opposite. And so then the second part of my paper, and I'm not going to have time to go over it, but I wanted to just mention it, is that I also argue that there's a theory going around that the fact that there is this whole movement for corporate social responsibility that exists, that somehow that movement shows that corporations can have religious beliefs. And I completely disagree with that because corporate social responsibility is a concept that asks corporations to do more, to try to act environmentally sensitive, have policies that improve gender balance. It is not asking to do less, which is what the plaintiffs in these cases are trying to do. And the things that the plaintiffs are trying to do here are not protected by the business judgment rule. And so I go into that. And basically, then I go into if employers want to see CSR, corporate social responsibility, as want to see contraception as a CSR issue, it is very, very much a CSR issue, but it's a choice. And so the arguments in these cases actually don't argue against CSR. They actually show that contraception is a part of corporate social responsibility. So thank you.
Thank you, Seema. Margaux.
Okay, I feel as the final speaker in the final panel that I should have brought sparklers or fireworks, something animated, but it's probably best for everybody here that I didn't do that. So I'll try to be as animated as possible myself. But I too wanted to thank the conference organizers, my fellow panelists, Jill, the other speakers, and also all the students, including the members of the Law Review, who have shepherded us around and made this a really wonderful past 2 days. So thank you all. This paper I'm going to talk about today is part of a larger project in which I'm investigating the ways in which we rely on third parties to make often very critical and intimate decisions about our health on our behalf. And in particular, I've been interested in investigating choice in those third-party relationships, both choice in terms of how or whether we get to choose those third parties, as well as what are the legal limits on discretion surrounding those third parties when they make decisions. So the starting point has been the fundamental question of who makes health insurance purchasing decisions on our behalf. And for the majority of Americans, approximately 55% of people in 2010, employers do. It's either our employer directly or the employer of a family member. And yet my concern was not just that employers have become the key providers of health insurance in the United States, it was that they are the key deciders. As David articulated as well, they decide what health services are covered on your insurance plan. They decide the cost, quality, accessibility, and the trade-offs between those. And as a legal matter, they have been able to do so to date as business decisions. And I should note, that they're not just making these decisions on behalf of employees, they're making these decisions on behalf of family members and an expanding group of family members now under the Affordable Care Act. So the tensions in this relationship and structural setup have been present for a long time and have oftentimes been their most pronounced when it comes to reproductive health services. So in vitro fertilization has long been a very controversial service. Is it covered or not in your health insurance plan? And now, of course, we see all of this bubbling to the surface through the contraceptive mandate litigation and questions over whether employers should be able to continue to assert this control over contraceptive care. So with respect to in vitro coverage, only 1 in 5 employers currently provide health insurance that covers in vitro fertilization. And those policies, even where employers do cover that particular service, they vary widely in their comprehensiveness and reimbursement limits, eligibility requirements. In the case of contraceptives, I don't think I need to go into too much detail here. We've been discussing that for the past 2 days. And while I don't respond to the religious freedom arguments directly in my paper, I was quite interested in that deeper structural problem at work. And I also wondered why employees' voices have been largely absent from the litigation and the discussion. So why are reproductive health services, or certain health services more than others, part of the sights of an employer's control? Well, I did a bit of research and I found varied and at times obscure reasons that coverage for services like in vitro fertilization would be denied. According to Anthem, Blue Cross, and Blue Shield, a quite large insurer, those services are, quote, insufficiently effective, experimental, inappropriate, or outside the practical scope of coverage. So that wasn't that satisfying an answer to me. I should note that all of these tensions, they can run in both directions. So you might have employers contesting offering contraceptives at the same time. You have a growing group of law firms, banks who now offer, as part of their health insurance packages, we will offer insurance that covers freezing your eggs, and we will also offer insurance that offers in vitro fertilization down the line. So delay starting your family and be a productive employee for us for however many years, and you can make the decision, later on about whether you want to start a family. So should we have similar concerns about both of these situations? And I believe we should, and we should really be concerned about what are employers' motivations when they're selecting particular services for a health insurance plan. And so I set out in this project to try to understand the legal character of this relationship. And as I mentioned before, for decades, the law has protected employers' decisions in this space as business decisions. There's very clear Supreme Court precedent interpreting ERISA that affirms this. And being the last speaker in the last panel, I promised that I wouldn't go into ERISA in too much detail, but I'm happy later on to discuss some more creative statutory construction arguments that I think challenge that existing precedent and really call it into question, particularly in the wake of the Affordable Care Act. But in general, I saw that characterization of employers' decisions as business decisions as stale and a bit outdated. And so I probed further, and I drew quite a bit on my prior work in writing in human rights, and first started trying to understand whether individuals have a claim of right or an entitlement to health insurance. And I believe they do in two basic ways. First, there are a set of statutory entitlements. So under the Affordable Care Act, a wide range of preventive health services are now offered on a free of cost sharing basis. More broadly, for years we've offered a tax exclusion to employees who receive their health insurance around the workplace, which is a significant subsidy that's effectively a 10 to 35% sliding scale depending upon an individual's marginal tax rate. And I should note a highly regressive form of healthcare financing, in that individuals in the highest tax bracket will get the largest effective subsidy on their health insurance purchase. But beyond those statutory entitlements, I think there's a more essential claim of entitlement that's grounded in the fundamental ways in which we purchase health insurance at the workplace. So just because contraceptives are now available on a free of cost sharing basis does not mean that we're not paying for them. Of course, those costs are subsumed in the insurance premium payments that we make. And typically, holding aside the tax exclusion, individuals functionally finance all of their health insurance purchasing either directly or indirectly. So directly, you might have a deduction coming out of your paycheck every 2 weeks or every month that's dedicated towards your health insurance plan. And then more indirectly, when employers are contributing to our health insurance plans, their actions are not philanthropic. They are there's a clear wage benefit trade-off that's at play here, and this is a functional portion of an employee's wages. And so just as employers couldn't and shouldn't be able to tell us what sorts of schools we can send our children to with our wages, I believe there's a sort of similar claim of right, and employers have a set of responsibilities with respect to that portion of our wage package. So I then characterized employers' activities with respect to those entitlements and found that it's highly discretionary. So just because you're purchasing, say, a $300 a month health insurance plan, employers have historically had all the discretion to decide what's in and what's out within that particular package. And given that highly discretionary conduct with respect to something that I believe employees have a claim of right to, I then recharacterize employers as legal fiduciaries. And by fiduciaries, I mean individuals who make discretionary decisions over resources that belong to a particular beneficiary. So we see fiduciaries make similar sorts of decisions when we hire an investment manager to take our money and invest it on our behalf, or perhaps a pension manager. And this framing of mine invokes private common law understandings of fiduciary law, which also have been incorporated, at least in part, into statutes like ERISA. So if you recast the role of the employer as a fiduciary vis-a-vis the group of employees, I should note, and their family members, whomever participates in a particular plan, then two fiduciary duties emerge as paramount in this analysis. First being the duty of loyalty. So fiduciaries owe a duty to act in the sole interest of that group of beneficiaries. They cannot consider their own interests, moral, economic, or otherwise. And the second being a duty of care. A duty of care that runs again to the aggregate group. So under that duty of care, they would have to conduct due diligence on insurers and see, do those insurers have reasonable reimbursement policies, but also a duty of care to better understand the group of beneficiaries and what their particular health needs are. I've been struck that through various employment arrangements, I've never had an employer actually ask me at the end of a particular year before the next enrollment cycle what my needs are. I've never had a form to actually express and articulate those. If you're fortunate, as about half of people are, then your employer offers more than one plan, so you can pick among the 2+ plans that are available. Oftentimes that still doesn't meet employees' particular needs, and so the duty of care would require some level of due diligence to understand what employees' needs are and then come up with a plan or a series of health insurance plans that best approximate the needs of the group. So considered in this light, the fiduciary framing provides a new lens to the contraceptive mandate litigation. First of all, in a fiduciary framing, the beneficiary, so in this case the employee or the healthcare user, they're at the center of the analysis. All of the duties run to those particular beneficiaries. It also seems clear to me that there's a quite evident conflict of interest, and employers have self-professed that they've breached the duty of loyalty. I should note that the fiduciary framing is value neutral, so it doesn't predict that contraceptives will win the day. You could imagine fiduciaries acting as trustees actually have legal standing to bring claims on behalf of beneficiaries. So you could imagine employers like Hobby Lobby bringing the same claims and saying, we're actually asserting these objections on behalf of our employees who object to contraceptives and don't want them included in their plans. But interestingly, we haven't seen those arguments emerging in this case. It's employers asserting their own value-based objections, irrespective of what employees' opinions are. There are also limitations that emerge that are quite common in fiduciary relationships, and one of the most significant ones I've been grappling with is this notion of path dependency. So if the duty of care requires an aggregation, and we know that women are historically underrepresented in many businesses and industries, then will we end up with this path dependency wherein employers just continue to provide the types of services that a certain group of employees want, and employees who have already been marginalized in the system will be systematically further marginalized? I think there are ways to perhaps minimize that risk through fiduciaries' duty to diversify risk, which would suggest that fiduciaries shouldn't just blindly ratify all of the decisions of their employees, but that just like investment managers have an obligation to make sure we have a diversified portfolio, perhaps we should think about health insurance in a similar way, where we diversify the risk of catastrophic loss from illness or poor health consequences. And yet, despite some of these lingering tensions, I'm drawn to the fiduciary framing rather than one of liberal individualism and free contracting, and that's because of the potentially strong benefits in these relationships. So the Affordable Care Act and a lot of the marketing around it has put forward strong paradigms of consumer choice. These new online marketplaces are supposed to be great shopping forums where you can decide as an independent consumer what health insurance plan is best for you. Do you want the gold, the silver, the bronze? And people are supposed to be empowered to make these decisions on their own. And I challenge that as our replacement narrative for this issue. I believe that individuals are highly vulnerable and reliant upon others when it comes to our health care, and that vulnerability is amplified, of course, when individuals are sick or ill. At the same time, health insurance purchasing is incredibly complex. Even experts routinely make miscalculations. So that's one of the beauties of fiduciary law, that I don't want to have to go out and research all the best investment decisions I could make. I'm going to hire an investment manager to do it because I believe the outcome will be better. And in a similar way, I think we can improve the quality of decision making by leveraging the skills and expertise of fiduciaries and these third parties to make decisions on our behalf. Whether those third parties should be employers, I'm not so sure, but that's the landscape we're left with, and now that's sort of enshrined in the Affordable Care Act. And there are clear advantages to having employers operate in this space, which are part of the reason why they've been attractive for years. Employers can be powerful negotiators vis-a-vis insurers. They can help minimize marketing and underwriting costs. You're pooling risk among a diverse group that's presumably not signing up for health insurance because they're sick. And in fact, it's probably a healthier group than most other risk pools you could form if people are able to be employed. And so in my ideal world, patients would not be making these decisions on their own. Regulation is not a problem to me in and of itself, but I believe that this important notion of patient protection, that was actually the first two words in the Patient Protection and Affordable Care Act, has been lost in part from this discussion. And so the question for me becomes, how do we guide those third-party relationships to ensure that they're serving health users' interests and not instead acting as third parties' business decisions? And I see growing opportunity to creatively consider private law's role in this space. Thank you.
So we're going to take questions now.
Hi, I have a couple of questions about reverse veil piercing. My first question is, what role does a management trust play in the whole analysis? Because with Hobby Lobby, it's the owners aren't actually the shareholders. Everything's put in a trust, and the owners are actually beneficiaries of the trust. And I didn't know what that added layer did to the whole analysis. That's my first question about reverse veil piercing. And my second is, I really wanted to hear a little bit more about what courts mean when they say they're effectively the alter ego. What kind of considerations have they actually looked at when deciding whether reverse veil piercing is appropriate or not? Thank you.
With the management trust question, I think that in terms of the analysis of, I think that would still go with the substantial, that would probably go that first prong with the substantial identity. Is that what you're thinking too? I mean, that's what I would say, that it argues even more for the more remoteness of the identities. And so it is not the substantial identity of the shareholders' religious beliefs, if you're going to use that framework. So for that first one. For alter ego, what courts have looked at is essentially, a lot of them have been with commingling of assets and basically looking at, are these really one and the same person? So if you're looking at a cab company that has an owner that has basically used his own funds and used the cab company's funds, and in the same bank account is essentially they're one and the same. That's kind of the things that they've looked at. Again, courts are very, very reluctant to do this in just regular veil piercing. In reverse veil piercing, it's in less than 10% of the cases, and even in those 10%, the majority of the reverse veil piercing cases are when outsiders, like the most common outsider is federal government, like the IRS, going in to try to get the assets of the corporation on behalf of the shareholder. So this type of values pass-through is so incredibly rare. I think it fails as a framework. I didn't get to go into that more in detail. So I'm using that framework as a last worst case scenario, and even then I think it argues for not letting the values pass through the greens and then their trust and then to the corporation.
Other questions? Caroline. Your questions are so good. They're welcome.
All right, so this is my this question's for Margaux. And so I tend to agree with you and think of insurance as part of employee compensation. But if you can bring people that far, do you necessarily need to take the last step to also argue about fiduciary responsibilities? Is it enough to say, listen, it's their compensation, we would never allow a company to dictate to people how they spend their compensation?
Right, so one of the responses to my article might be that isn't this just a term of employment, and employees sort of know the health insurance that they're purchasing and they could negotiate that from the outset, or as you're suggesting that this is part of the compensation package and so they have duties with respect to it. Health insurance is different, though, from standard compensation in that you're not giving out, $300 of cash wages. That's a very clear item that you're giving out. Instead, they're giving out a package of insurance services that have a highly discretionary content within them. So I think without, and again, as I mentioned briefly at the end, I'm hesitant to think of a world in which employees have to independently contract for everything that should be included with that $300. So instead, I do think you need that final step to describe what duties, if they're going to be shifting contents year by year, then what duties would employers have and what process should they go through in deciding exactly what to purchase with those funds. Overall, this whole employment landscape is incredibly messy. So even though there seems to be a clear wage benefit trade-off, in the short term, wages are quite sticky. So you don't see employees saying, well, I'd rather have a health insurance plan that's only worth $100 a month and give me the other $200 in cash. So that level of negotiation hasn't really taken place to date. I think there's reason to hope that it might a little bit more. 'Cause now under the Affordable Care Act, employers will have to disclose how much they're actually contributing to health insurance on your W-2 statements. So we might actually near a space where employees can actually even have the opportunity to negotiate how much of their compensation is actually coming in the form of health insurance versus sort of cash wages. But I think even in that instance, you would need some residual framework to decide and guide employers in making decisions about the contents of the insurance plans.
Great. Other questions? Lee?
So David, I'm sympathetic, and I think probably most of the people in the room are sympathetic to the idea of the ACA as anti-subordination legislation. But politically, do you think that that's an effective reframing of the narrative in terms of trying to defeat some of the opposition to the law, given the historical racism and the historical sexism that you talked about?
Well, I think it comes back to talking about, who benefits from the law and framing it that way. And so, a lot of the discussion we've had today is about, where are the third parties or where are the affected employees in this process? And I think, when we come back to that, then we get, toward those issues of addressing anti-subordination. But at the bottom, I think another way to talk about it is, addressing health disparities. And one of the things that makes our system so expensive is that there are these incredibly costly health disparities that exist in it. And so if we're all going to be in the system together, we want to have the system that provides the best care at the lowest cost to everyone, not just the best care at the lowest cost to certain people who are already getting the best care at a pretty reasonable cost before this.
So David, when we were talking in preparation for this panel, you talked a lot about this idea of disparity and that it was really missing from the conversation. Do you have suggestions or ways that we could bring it into the front or the fore of the conversation?
Well, I think that it's been done, again, to some extent, the feminists have understood this. I guess that's the other point, that we need to not be talking about, sort of, well, in the context of NFIB versus Sibelius, we were talking about insurance markets, and there were these long colloquies in the oral argument where people talked all around the fact that emergency departments are required to accept you and treat you when you present with an emergency, but never named the statute, the Emergency Medical Treatment and Active Labor Act, EMTALA, and never said that one of the reasons why we enacted EMTALA was because black people couldn't get served at hospitals. We had this whole, part of the stuff I didn't get to talk about is that when Truman, the one part of Truman's healthcare reform, that national health insurance or national health care program that he was enacted was Hill-Burton, which put, billions of federal money into hospitals. Hill-Burton contained a provision that allowed there to be separate but equal hospitals built in the South. And it wasn't until the passage of the Civil Rights Act and Medicare that hospitals were desegregated in the South. So you have this long tradition of being able to, discriminate against who gets treated. And so, again, we have to think of this in terms of, some of the history, and we want to have a system where everybody has access. And I think people don't realize, we've come to the basic agreement that we don't want people to die on the streets. We want, the rule that EMTALA represents to be in effect. That when you go to the emergency department, you get treated. They don't check your race, they don't check your religion, they don't check whether you have insurance, they just treat you. There's a cost to that. And I think we did a terrible job, that is the supporters of the ACA, of explaining why it is important to have a system that works that way, and why the Affordable Care Act had the individual mandate to help pay for that.
Other questions?
I actually had a question that maybe I'll throw open to my co-panelists and others. When I first started working on this project, I wrote an op-ed, which I never published, that suggested, there might be reasons why even reproductive rights advocates might want this contraceptive mandate litigation to succeed, because it could help successfully unravel employment-based coverage and create sort of similar to what David was just, describing, these disparities that exist. I see many of them as rooted in how siloed and atomistic a lot of our insurance pools are, with having the healthiest and typically wealthiest people in their private employer-based plans. Then you have, Medicaid, you have the elderly population and Medicare, and perhaps if we could unravel this 55% figure and integrate it, you could end up with some system that's more cross-subsidizing. And over the past few months, I've been thinking about that more and wondering, what would be a more perfect order than employers? Would moving to state-based marketplaces or, a federal marketplace and federal insurance plans actually be better from a reproductive rights, reproductive health standpoint, when we see a history of major challenges in funding when it comes to reproductive health services in those places? I don't know if you both have thoughts on it, but it's something that's been mulling around in my mind quite a bit lately.
Well, the one thing that comes to mind right away from your question is, I keep thinking that they keep delaying the employer mandate, and there's a part of me that thinks, what, let's just forget it. Let's just send everybody out to the exchanges and go from there, because I think that that way. If you have, the exchanges set up to provide people, a specific set of benefits that people can go out and purchase, then, they're really, you get out of this problem of, the small risk pools and employers making those decisions and all those kinds of control issues.
Seema, what do you think?
I've come up with a brilliant idea. I'll let you know.
Well, thank you so much to our panelists for traveling and sharing their thoughts with us. We wish you luck on your papers.
For those of you who I haven't met, I'm Lee Goodmark. I'm the only co-director you haven't seen yet. And I am the light at the end of your tunnel for our day today. So I just want to close today by, once again thanking all of our presenters who've just been amazing today. So another, please, recognition of them. To thank our committee that does, so much work. One of the things that the center is founded on is the idea that we have these groups that work together to do all of these things that we do, and our committee is really invaluable. To thank the Law Review and the students from the Law Review who've been here working hard all day, and the students from SSWLC who've been working here all day. And once again, to thank Brittany Martinez, who again is not in the room. It's not an accident that this center, which focuses on applied feminism, the way that feminism works in the world, was created by clinical law professors who are uniquely thinking about the way that this stuff works in the world, I think. And so, as clinical professors, one of the things that we focus on a great deal is storytelling. The workshop last night and the papers today have really shown us the power of narrative, and particularly the need for counter stories. Counter stories are what we use to subvert the dominant narratives that are told by people in power to justify their actions, their law and policy choices. Counter narratives are the stories that we tell that give voice to women who are not currently being heard. Today has been all about reframing. We need to create counter narratives that are powerful enough to ensure that women's health care needs are being met. So whether that reframing looks like what we talked about in the workshop last night, right, between the difference between abortion as opposed to reproductive justice, and that much broader idea of reproductive justice. Whether it's about reframing women's rights to contraception instead of the religious freedom of companies and corporations. Whether it's about reframing narratives around breastfeeding, or about mothers as the primary sources of harm to their children, around sex selection abortion and the myth that exists around sex selective abortion. Whether we start talking about honor killing as a health issue, as opposed to necessarily just a rights issue. When we talk about the importance of the Affordable Care Act as promoting free labor and women's autonomy, or promoting corporate social responsibility, and about what the duties of employers who provide health care are, as opposed to the business choices that they're making. All of these counter narratives are essential. And they're so important not just in changing law and policy, but to change the political discourse that exists around these issues. And as Terry O'Neill reminded us in her talk last night, it's not just about talking, right? It's also about persuading voters to elect those people who can make the changes that we need to law and policy. So we appreciate the stories that you've told today. We appreciate these counter narratives. We look forward to working with all of you to continue telling these stories, and in doing so, to make the change that women in this country so badly need around their health care. It's been an absolute privilege to do this. I have to say, this year, because I'm not here, all credit goes to Margaret Johnson and Michelle Gilman, who did all of the hard work around this conference. I, like you, mostly just got to enjoy stuff. And so, last but not least, of course, thanks to my amazing co-directors, who I love dearly and who I appreciate so much. Thank you all for coming.